Okay, so welcome everybody. Tonight I'm very happy to welcome Samantha Knights, our guest tonight. Samantha, it's great that you have the time to do a presentation tonight for us about law, rights and religion, the role of religion in a secular legal system. That will be the title of Samantha's presentation. We had the luck to have Samantha as a guest before. Last year, she presented at our Human Rights Summer School, and we are also connected because we both teach at the Miami Law School. So the connections between Leipzig and Samantha are there. And although, of course, we were not able to invite you in person to Leipzig, which is a pity, of course, and we'll do that in a post-corona area. And we are very happy that you're presenting about law, rights and religion via Zoom tonight. I would like to introduce Samantha. Samantha is a barrister and also a Queen's Counsel, which means she's appointed by the Queen herself, which is an honor, of course, and which is only done to a certain amount of barristers in Great Britain. So this already shows that she's a very distinguished barrister. Her interests are very wide in a positive sense. Samantha is doing commercial litigation, immigration and asylum law, and other things of public and international law. She has presented a number at the European Court of Justice and also at the European Court of Human Rights. Very interesting cases, by the way. And what I found very interesting, you hold a bachelor in history, I read, and you worked as a journalist. You started off as a journalist, as I did as well, by the way. And you worked for an English newspaper in Estonia. And at that time, you came in contact with detainees that had been cheated by traffickers and dumped on the shores of Estonia instead of Sweden. And as I understood via that, you kind of became entangled in matters of immigration law and asylum law, and now you're one of the leading barristers in this field. So I'm very happy that you found the time to give a presentation tonight for us, for our researchers and for our students. And I think the topic, which is connected to Samantha's new book. Her book is about law, rights and religion, which is coming out shortly at Oxford University Press. And your presentation tonight is connected to this book. And I think the topic is very interesting. And of course, it's a topic concerning one of the most pressing issues at the moment. We have seen in Vienna yesterday one terrorist attack again in the name of the Islamic State. And what happened in France is concerning us as well very much. And the whole role of religion in a secular system is a very complex issue, and I think we in Germany haven't discussed this issue so far, not in the whole broadness which we should actually. And so I'm very much looking forward to the insights Samantha will be giving us into the role of religion in Great Britain. And maybe we can draw some things to general ideas to the role of religion in secular legal systems, and also confer this to our situation in Germany. Samantha, we are very happy to have you here. Please, you have the word. Thank you.
Stephanie, thank you so much for that very kind introduction, and thank you to the law faculty of Leipzig. It's a great pleasure to be with you this evening, and I really do hope I will make it to Leipzig at some point. Little did I realize last year when I spoke at the Summer Human Rights Programme by Zoom that this would become the new norm. And I thank you also too for being able to give this talk in English, although you really wouldn't want to hear my school-learnt German, which needs quite a bit more practice. This is actually the first time I've spoken about my book, although I don't unfortunately have a physical copy yet to wave at you, and it should have been coming out next month in December, but because of various delays, but due to the current pandemic, it's now going to come out in February of next year. So by then I'll have a copy, and you can, of course, pre-order it in any event. So I'm going to talk for about 35 minutes, and I will try and keep an eye on the clock because I want to give plenty of time at the end for us to have a discussion, and I'm happy to take questions on on anything, including on generally on the English legal system. But I've got a PowerPoint, so I'm just going to share that at the moment, and let's hope the technology works. Great, I think you can all see that. There we go. So I just wanted to start off by actually just saying a little bit about how the book came about. There was an earlier edition in 2007, which is really the precursor to the current one. It all began actually in about 2002, and I was sitting around with some friends over dinner and a glass of wine, and a number of my friends had children at that stage, and they started talking about the issues that were arising in the schools and how religion was being taught, and then this very odd situation, as I thought, of having religious worship in the school. At the time I didn't have children, and so I hadn't really thought about these things, but it made me think about my own schooling in the 70s, and I started remembering how this odd thing of the local vicar from the church coming to talk about Bible stories, but then they were incompatible with the science that we were being taught. And then later, when I went to a secondary school, we were required to go to weekly chapel services. But I didn't really, as you don't at the time, I didn't really think very much more about it. But it certainly, this discussion with my friends sparked my interest, and in particular because it was actually quite rare to have conversations about religion at the time. I mean, we were a very diverse group of people with no doubt different beliefs, no religion of different types, but we didn't really talk about religion very much. And so, it made me think, well, what was happening currently in the schools? I thought we're now an incredibly diverse society by 2002. Surely religious worship isn't required still in the English public school system. So I had a look at the law, and I realized it was. There it was. It had arrived on the statute books in 1944 in the Education Act, which required a daily collective worship in the school, and which had to be of a broadly Christian character. And it also required religious education. As with many aspects of the English legal system, there were carve-outs, there were exemptions, and so that if, for example, a school was made up predominantly of Muslim pupils, then of course they could opt out of the requirement of having daily worship of a predominantly Christian character. But it gave rise, of course, to this problem of how you can have a one-size-fits-all system within a very, very diverse society. And it also seemed interesting is how you would teach religion, in this kind of setting. Who should teach religion, and from whose perspective, and what religions should be taught. So anyway, this led to my dissertation while I was studying a master's in law at the London School of Economics. And then thanks to a research grant at the Islamic Legal Studies program at Harvard, I spent a year doing research for the first book, which is the one on the left. And I actually vowed I wouldn't write another book, another emanation. But of course, by 2018, when I started the second book, an OUP actually approached me and said it would be a really good idea to update it. So much had happened in the world, both in terms of the shifting of the population and the population's beliefs. And as Stephanie mentioned in her introduction, there were so many issues involving criminal law, criminal acts, terrorism in the name of religion. And these sort of religious issues kept coming to the forefront, whether they're in the setting of employment, people wanting time off work for different reasons, or people wanting to wear religious clothes in a school system, for example. So here we are. The second edition hopefully should be with us soon. So I wanted to start by just sort of situating, if you like, this English law paradox and really sketching out in the next half an hour just the three preliminary chapters of the book, which deal with the historical, the socio-political context, and the relationship between law and religion, and the role of a secular legal system in deciding cases which involve religion. And as one of our Court of Appeal judges, Lord Justice Mumby, as he then was, recognised many years ago, we do have a paradox. Historically, the United Kingdom is part of the Christian West, and it has an established church, which is Christian. But it has a society which is pluralist and increasingly secular. The society, at the same time as becoming increasingly secular, is also becoming increasingly religiously diverse in terms of affiliation. The judges, however, sit as secular judges and serve a multicultural community of many faiths, and the laws do not include religious laws per se. So the starting point of any court case for the judges is one of respect for religious beliefs, coupled with an essentially neutral view of those religious beliefs. In other words, the judges can't prefer one religion over another, or prefer non-religion over religion. And the judge needs also to be careful not to stray across the divide between the church and the state and weigh religions up against each other. And yet, and this is the paradox, judges frequently have to make decisions involving competing views about the space in a society which should be given to religion. So, for example, just to give you an idea of some of the cases which have come before the English courts, does a Christian cake maker have to make a cake with a message support gay marriage on it, a message with which it profoundly disagrees? Can a Jewish employee leave work early on a Friday for the Sabbath? Can a Muslim schoolgirl wear a full-length jilbab to school, so essentially a Muslim covering? Does a Christian employee have a right to wear a cross at work? And can a Hindu group prevent a cow with bovine disease from slaughter under health and safety law? And as I say, these are all issues which have come up before the English courts. But I wanted to start really by going backwards in time, because to understand where we are and how religion and law interact, we do need to know a bit of history. And this, of course, is something which law students, in England at least, don't necessarily study. I happened to do a law degree before I did my, a history degree before I did my law degree. So I have an innate interest in history, but I certainly didn't study the history of religion, nor the history of the legal system when I was studying history. So Britain has always been very diverse religiously, and the early history of England is one of many different cultures arriving. You'll see probably the perhaps familiar image of Stonehenge on the top left, which has been adopted very much by Druids in England. It wasn't built by them, but they've certainly, they have adopted it as one of their sacred places, and there are special provisions on the summer and winter solstice for people to gather there and worship there without having to pay any entrance fees. The Crusades, and that's an image at the bottom left of the screen, the Crusades in the 11th century brought, of course, a notion of Islam to the UK, and Muslims started arriving in Britain in the medieval period, and by at least the period of Elizabeth I in the 16th century, there were a number of Muslims, including some in her court circles. So, you know, Islam has got an early history in England, as well as Judaism. But at this time, there was no concept of freedom of religion in the common law as it developed. And of course, I'm sure you'll know well, at least the history of the German Reformation. The picture on the right, this is a picture of Henry VIII, who was the architect of the English Reformation. Reformation ideas coming from Luther were, of course, in circulation in England at the time. But it was really the hazard of his desire to have an heir to the throne and not being able to have a child with his wife that brought about the break with Rome and the creation and the establishment of the Church of England. And that had an absolutely dramatic effect on religion in the UK and on the relationship between the state and religion. So, as well as the destruction of monasteries and the destruction of many aspects of Catholicism and Catholic traditions and icons and things in our churches, there was a huge impact too on the religious services, on the language, and so on. So, what about the diversity of religious beliefs in the UK today? And this actually is interesting, and it surprises people when they actually drill down to the figures. We have in England every 10 years a census. So the last census was 2011. We're due to have one next year. The last census, which is it's sent out by paper, and every single household in the UK is required to fill it in. Every single adult in the UK is required to fill it in. It showed 59.3% of the population were Christian. This was a dramatic fall in Christianity identified, and down from a figure of 71.8% 10 years previously. But interestingly, there's no breakdown in the census of Christianity. So no, you couldn't say, for example, looking at the census results, whether there was a majority of people who believed in the established church, in the Anglican Church, Church of England. Also, interestingly, a quarter of the population were described as having no religion. And about 5% of the population were Muslim, and there were lots and lots of other different religions represented. But much more recent polls, and even polls done around the time by various organisations, showed that the decline in Christian belief was actually far greater than that shown by the census. And one highly respected survey showed in 2017 that 50% of our population are not religious, and only 20% adhere to the established church. And we can see also in terms of numbers of people who go into churches, in the sort of decline of churches and their relevance in society, and the sense that the established church is in some sort of crisis, if you like, in terms of its popularity. So it'll be interesting to see what happens in the next census. But certainly we can, I think, say with considerable degree of certainty that we are no longer predominantly a Church of England country, and yet we have an established church. So what about the church-state relationship in in the UK, we need to know something about this because it explains, on the one hand, the level of state interference in religious affairs. It explains the importance which is ascribed to religion and the way that the state seeks to regulate the affairs of religious organizations. And it also helps us understand the positions of differing religions and the way that, on the one hand, a state may, if it's got an established church, may also need, therefore, to give some degree of benefit to other religions, and at the same time, still allow that established church to have a dominant and privileged position in the society. So as you may know, there are various different types of models. You've got everything across the world from states which are de facto religious, a number of states in the Middle East, including somewhere like Saudi Arabia, you would describe as a religious state. The laws will reflect the religion, which in that case would be Islamic. At the other end of the spectrum, you have the secular state, and there are various models for that. You have the wall of separation in the United States, for example. In France, you have a state which describes itself as laïque. But the label of a state as secular doesn't mean, of course, that it doesn't support religion in some ways. There are all sorts of ways, for example, in the states in which religions are effectively given, indirectly given funding or support by the state. In England, we have an established church, as I've said, an established Church of England. And so that means that religion occupies a very public space in society, which is recognized in law. And so this is really of importance in understanding how, especially in the Strasbourg, using the Strasbourg norms, how cases are decided differently for the United Kingdom than they would be, for example, in France. One example of that, which came up relatively recently, was a case called SAS in France, which was about a ban on face coverings in France in public spaces. Although it was on the face of it a neutral law, in fact, it was designed to target the Islamic headscarf. And that the decision of the French courts to uphold the ban was also upheld by Strasbourg. That case would have been decided, I think, very differently by Strasbourg in the context of the United Kingdom, because we have religion in the public sphere. We're not a secular society, and so we don't have that hostility, if you like, to religion in the public space. So what about the Church of England and its privileges, and what does it mean, in real terms? So we have 26 senior bishops who have a seat in our upper House of Parliament, in the House of Lords. So that means that they're taking part in political debates, and they are part of our politics. Until 2013, there was a ban on the monarch marrying a Catholic. That's now been abolished, but the fact that it remained enshrined in law until 2013 is incredibly striking. And until 2008, the Church of England was the only church, the only religion in England which was protected by the offence of blasphemy and blasphemous libel, and attempts by other religions to have blasphemy applied to, for example, Islam, failed. And the Church of England also has exemptions from Equality Act provisions and anti-discrimination provisions. So, for example, when the church wants to appoint somebody within the church, then they can discriminate on grounds of religion, and there are also provisions allowing them to discriminate on grounds of age. So it has a very privileged position. This privileged position has led a number of people, and in particular the Humanist Society, to argue that it should be disestablished. But there's little political appetite. Certainly right now, no prospect, of course, of anything like that happening. But even without the current pandemic, the Brexit sort of issues, the issues around the global economy, it was never really a political issue, although there have always been strong arguments for reform. So then moving on to the law and the courts and how religion has sort of entwined itself in our legal system. We have, on the face of it, now in England, a legal system which is essentially secular. But religion and Christianity remain embedded in the system with deep historical roots. Whilst, as I said at the outset, the legal system, the formal legal system, doesn't purport to favour any one religion, judges therefore must make decisions based on the law rather than on religious views. But nevertheless, it is recognised that religious heritage, the religious culture and the traditions of our Judeo-Christian culture have a significant impact. And as one very respected judge, the late Lord Justice Laws, said, the Judeo-Christian tradition, stretching over many centuries, has no doubt exercised a profound influence upon the judgment of lawmakers as to the objective merits of policy. But the conferment of any preference upon a particular moral position on grounds of religion would be deeply unprincipled. So we still have a problem. Complete neutrality by the judiciary, of course, is not possible when considering what is fair, what is reasonable, what is proportionate. Judges will inevitably bring to bear their entire social, moral compass and their own outlook. And it's well recognised that fairness is a very elusive concept. If you ask me to define what is fair in any given situation, you'll get, no doubt, a variety of different views. So I mentioned that the study of the history of the legal system and the court system isn't required for law students. So most people will, when they're looking at laws of the present day, will not necessarily understand the legal history behind them. But in brief, the laws of the early medieval monarchs onwards reflected, of course, a predominantly Christian tradition. Judges were sent out from the royal courts. Initially, they were often bishops or graduates in canon law. They were really the only literate members of society at that time, and they held positions of trust within the royal court. The notion of equity, which is something which is very important to the common law and to the law of England, and the courts of equity were founded on Christian ideals of equity, and this is something that people such as Thomas Aquinas have written a lot about. So the development of our common law system owes a lot to Christianity. And at one time, Christianity was actually considered to be part of the theory of the common law. This is no longer the case since the 19th century, but nevertheless, these traditions and this culture is deeply embedded. And just to give you an idea of some of the ways in which Christianity is embedded in our so-called secular laws. So I've spoken already about the requirement of religious worship in education, in schools in England. In family law, we have the concept of what a family is very heavily based on Christianity, on the idea of a married couple with children. Now, of course, there are now lots of reassessments of that, but it is essentially focused very much on the concept of the Christian family and that tradition. In employment law, the days that typically people have off work, certainly until perhaps relatively recently, Saturday and Sunday were days recognised by the Christian calendar, and the Sunday trading laws, which allowed shops to trade on Sundays, similarly came out of that tradition. In immigration law, polygamy, for example, is not recognised. So if a man who has more than one wife wishes to bring their spouses to the UK, under immigration law, typically you're allowed to bring your spouse into the UK. In the case of somebody who's got more than one spouse, you could only bring one. You have to choose one of those. Again, a reflection of a religious culture that has abolished polygamous marriages. In prison, prison is actually one of the few places where when you enter a prison, you are required to cite or state your religion or the fact that you have no religion. And the prison chaplaincy system is a deeply important part of the prison, and started off as really as a Christian construct to try and rehabilitate people. Health and safety laws also reflect the dominant tradition, and there are exemptions, all sorts of exemptions carved out for religious slaughter of animals, for halal and kosher meat, and even requirements in terms of wearing hard hats on building sites, and the exemption granted to Sikhs wearing turbans not to do so. And commercial law, one doesn't typically think of commercial law as involving any real sort of notions of freedom, but there's a lot of academic research now about the origins of commercial law and religion, and the concept of good faith, which is very much a part of the English law of contract, of course, is embedded in religious law. So, how does religion manifest itself in other ways in what is a secular court system? On the left, you'll see a judge who's actually a very dear colleague, former colleague of mine at Matrix, now Lord Justice Singh, who is a Sikh and therefore not wearing the wig, which would otherwise be worn by the judiciary, wearing his turban. So the vacations that courts have, they reflect the Christian calendar. The oaths that people swear on when they're giving testimony in court, traditionally people had to swear on the Bible. Now that's changed, you can swear on another book, religious book or no book. The language of the court, again, was Latin and very much bound up with the literacy and the use of language, Latin being the language of the clergy and the clerics, who originally were the sort of sole people in the country who wrote. The dress of the court, the robes, again reflect the Christian traditions. Judiciary now have a huge amount of guidance given to them on different religions and how to understand and, if necessary, make adjustments for people, witnesses coming to court, for example, who may need to not be able to give evidence on a particular day because it's a religious holiday. So there's a book, a bench book, which gives guidance to the judiciary. We also do have, although we have a secular formal legal system which decides things like contract disputes and torts, and criminal law is secular, family law is secular, we also have a system of religious tribunals and ecclesiastical courts. So the ecclesiastical courts are a very long-standing tradition and existed all the way through the history of the legal system in this country. They now sit completely separately. They are effectively part of the formal legal system, but their scope of jurisdiction is very limited. So, for example, something like the decision about the building of a particular church or the renovations of a particular church would be decided by the ecclesiastical courts. Things such as burial grounds, worship requirements, if they're ever disputed, those are the sort of things that would go to ecclesiastical courts, and they would apply canon law and the law of the Church of England. But we also have other religious tribunals which are not part of the formal legal system, and some of those have existed for a very, very long time indeed in the UK. This includes the Jewish Beth Din and Sharia councils, but there are also other religions who have their own tribunals. So one question that comes up sometimes in English courts is, can we take into account the decision which has already been made by a religious tribunal? And this comes up very often in the family court. So, for example, somebody may wish to be divorced, and the question is, well, are they in fact married under the eyes of English law? Have they gone through an English law marriage? They may have only gone through a religious marriage in a religious setting. So, what does the family court make of that? So the family jurisdiction will not be bound by any religious tribunal, by the decision of any religious tribunal, but on the other hand, it can take the decision into account, but it will always preserve its own jurisdiction to apply English family law and to apply what it considers to be fair and reasonable in all the circumstances. And the one exception to this is arbitration. So if a religious tribunal, such as the Sharia court or the Beth Din, has made a decision in a commercial or a contract case, and it meets the requirements of the Secular Arbitration Act, then the award made by that religious tribunal can be enforced through the secular court system as an arbitration award, and that's the one exception. There's been quite a lot of interest in religious tribunals in the last decade, in particular in the Sharia councils, and whether they are fair to women, and the concerns really about human rights issues, and whether women are forced into using them or not. And there's been quite a lot of research into this, and I know there has been in Germany as well. So I wanted then just to wrap up, talk about freedom of religion, and just give you a kind of very quick overview of how a freedom of religion has emerged, and then just to talk about one case to exemplify the issues. So, as I mentioned, there was no freedom of religion, no religious right to religion in the English common law. And although English law, certainly from the 19th century onwards, was generally tolerant towards different religions. In other words, different religions existed in the UK and they coexisted. But if cases came before the courts may be able to arrive at a just result by applying concepts of fairness and other sorts of things. But there was no positive right to freedom of religion. And nor was there any right not to be discriminated against on grounds of religion. That changed somewhat for certain religions in the Race Relations Act in 1976, which was one of a series of anti-discrimination acts passed in the wake of the civil rights movement in the United States, which had also profound impact on race relations in the UK. But the Race Relations Act, whilst it protected Judaism and Hinduism, for example, as having a concept of race, Muslims were not protected by the Race Relations Act. So there was a lacuna in the law. The law of freedom of religion was only really brought into direct effect by the Human Rights Act 1998. Prior to that, if you had a case involving freedom of religion, you couldn't rely on the European Convention directly in the English courts, although you could petition to Strasbourg once you'd exhausted domestic remedies. The Human Rights Act brought the European Convention of Human Rights into direct force in the UK and required judges to directly apply it. So that was an incredibly important piece of legislation and remains so to this day. Then there were various emanations of Equality Act, culminating in this Equality Act 2010, which brought together lots of previous acts relating to equality and non-discrimination. And of course, there are EC equality directives and an EU Charter of Fundamental Rights. So at the moment, the freedom of religion is protected, and there are anti-discrimination provisions in the law, very much as there are in Germany. But the real question is, in the individual case, how does one decide competing interests. And so I just wanted to end by just talking about one case. It was a case about a small Christian-run family cake making business. It was essentially a couple who made cakes, and they would make a cake with a message, or they would draw an image on the cake. So it was a bespoke cake making service. And the baking company was in Northern Ireland. Any of you who know something about Northern Ireland will understand the religious tensions in that part of the world. So the baking company couple believed that the only form of marriage consistent with biblical teaching and with Christian principles was that between a man and a woman. So they didn't recognize same-sex marriage. Mr. Lee, on the other hand, who was the claimant, wanted to get a cake to take to an event organized for same-sex marriage in Northern Ireland. And he wanted the words "support gay marriage" to be iced on it. The order was taken initially, but then Mr. Lee was told, no, you can't have the cake. And I'm terribly sorry. They were very polite, they were very apologetic, but they said, I'm sorry, this is contrary to our beliefs, and they gave him a refund immediately. But that wasn't the end of it. Mr. Lee decided to make a claim against the baking company on the grounds of equality law under Northern Ireland equality law provisions and under the European Convention. Now, two courts in Northern Ireland held that the refusal to make him a cake was direct discrimination. The First Instance Court and the Court of Appeal. A reference then was made to the Supreme Court, the United Kingdom Supreme Court. The Supreme Court, however, overturned the decision of the lower court and said there was no discrimination on grounds of sexual orientation because the refusal to bake a cake was based not on any personal characteristic of Mr. Lee. In other words, it was nothing to do with Mr. Lee's own sexual orientation. It was simply because they disagreed with the message. The more tricky question was whether there was an interference or whether there was discrimination based on his political opinion. And there the court said, well, the situation isn't the same as people who are refused jobs or services, although it was arguable that the message was connected with his political opinion. And so they needed, therefore, to consider whether under the European Convention of Human Rights or under the equality law applicable in Northern Ireland, there was discrimination. And the way they interpreted Article 9 of the Convention in this particular setting was that the baking company, could not refuse to serve Mr. Lee a cake because he was gay or because he supported gay marriage. But that was a different situation to obliging them to make him a cake with a message with which they disagreed. And so they said the equality law shouldn't be read in this way unless justification was shown, justification for reading that was shown, and there was no justification in this case. Now, on the facts of the case, Mr. Lee was able to go to another company and get a cake with the message he wanted. So, you might say, well, okay, he eventually got his cake, although that didn't obviously decide the principle. I wrote a blog piece in which I questioned the decision of the Supreme Court. I mean, it was obviously carefully thought out, carefully argued. You can see the Supreme Court, a little image of the Supreme Court judges on the left. And first of all, I said it wasn't clear to me why Articles 9 and 10, so the rights of the family to their religious views and their, if you like, free expression, trumped the non-discrimination provision. So there was a very clear non-discrimination provision in Northern Ireland law, and it wasn't clear to me that the case really was simply about the message. And I questioned too whether the cake was really about the expression of the cake maker. in other words, if you analysed it in the way of if it was a printing shop, for example, somebody simply went into a printing shop or a T-shirt making business and asked for a logo to be put on the T-shirt or some words to be put onto some paper, is the company really aligned with the message? I'm not sure that they are. I also questioned, what if the message was merely a picture? What if the message had been about race? So what if the cake message had said in support of interracial marriage, multicultural marriage? What then? And interestingly, this at the same time as this case was going through the UK, there had been previously a very similar case decided by the US Supreme Court. And I went to a debate while I was in Miami between the parties who had been involved in that case. And they effectively, before judgment was given, they effectively argued out the case in front of the law students at Miami University. And the issue of race came up, which is obviously incredibly sensitive in the United States. And everybody agreed that, oh, well, if it had been about race, no, you couldn't have discriminated in that case. In other words, you would have had to bake the cake because race is so sensitive and it's different to sexual orientation. So that I thought was interesting. And the other thing that troubled me about the decision was that if every single baker had refused to bake a cake, then what then? Would he have been left with, without a cake? It wasn't part of the judgment at all. But obviously the judges, I think, would have known by way of the background that in fact the cake had been made by somebody else. So there was no, if you like, there was no practical damage, perhaps. Anyway, that's the current state of the law in terms of baking company. But one has to be careful not to, I think, read too much into one decision. These decisions turn very much on the particular facts of the case and on the wording of particular statutes. So one can't read too much into any one case in terms of understanding, if you like, the striking of the balance between the competing beliefs of parties or the status of religion and law. So I'm just going to stop there now and then open it up to discussions and questions. I'm going to stop sharing as well so we can get this off the screen.
Thank you very much, Samantha, for your presentation. I think the case about Lee versus the baking company shows very nicely what we are talking about, religion, and also the influence of this in like everyday life. So actually, I found the case very interesting, and also what you said about the US perspective on this, that race is a very different thing. Race and religion are considered to be very different. So I wondered how this would be seen in Germany. I don't have a clear answer to that yet, but I think this is really something special also to the history and of the US system, that race is kind of really a special thing when it comes to discrimination. I think, yeah, probably one can talk a long time about that, but I think in Germany, religion and anti-discrimination law is not as much combined as it is, for example, in the UK and also in the US. Like freedom of religion has been one of the traditional rights, and the kind of anti-discrimination law is, a lot of it came through the European Union. And so it's not as much, equality and religion is not as much combined in Germany as it is in other countries, I think. Which I just realized when I heard your talk, Samantha, actually.
Yeah, one of the interesting things in the US as well is the great strength of freedom of expression. So relatively, and I think it's true both for Germany and the UK, relatively freedom of expression in the US is given much more weight than it would be in the UK. So both in Germany and the UK, we have, for example, hate speech laws, in criminalizing certain types of speech, in Germany in particular, of course, relating to people, who might choose to try and deny the Holocaust, or that sort of area. And in the UK, nothing so specific, but we have hate speech laws. Hate speech laws don't exist in the US. So that's sort of one thing. And so the Supreme Court decision about the cake in the US, the facts were slightly different, but not so very different. It was really decided on religious expression, on freedom of expression grounds, that you couldn't interfere with the rights of an individual to express themselves, and if they didn't they didn't want to write a particular message, then they couldn't be forced to do so. And that wasn't a route that the UK court went down because of the different legal provisions, but it's certainly something which is interesting in this area.
I don't know if this is my connection. I think the connection was bad at the moment. Was it just my connection, or could you hear everything clearly, the others? Okay, so I think my connection is a bit, I just didn't hear the last words, but of course, you're absolutely right. It's a matter of freedom of speech as well. Maybe before we dig into the discussion more deeply, which is interesting, by the way, I would like to open the floor a bit wider for our students and other listeners, and open the floor for questions for Samantha, and questions concerning the system of the UK, the special role of religion in a secular state, like Samantha presented the special role of the churches of England, which was very interesting. I think I didn't know that there was a ban on marrying a Catholic until 2013, which is showing the very strong connection also of, yes, of course, of the England to the state of faith and to the crown as well. So I didn't know that, and I found that very interesting. And also that there was the offense of blasphemy until, I think you said 2008. Did I get that?
Yes, 2008. Yes.
That is, I think, also a very interesting thing. I didn't know. But I would like to open the floor a bit more. Do you have questions for the British system in general, and also for the special, those specialties? I don't know. Could you say that the UK is a secular state? Or is the Church of England so much entangled here that one could do a question mark behind the term secular state?
We're definitely not a secular state. We are a religious state, but we're not a religious state, in the same way that Saudi Arabia is a religious state, because our judicial system does not apply religious law per se. So we're establishment light, if you like, but we're not a secular state, and I think that's incredibly important when you kind of come to look at the role that religion plays. We're not hostile to religion in public spaces. We're not hostile to religion in education system, in the workplace. So the balance between different religions is something which comes up time and time again.
I think I think you said something that Christianity is embedded in the system, and I think this puts it very nicely, and it's also the same in Germany. Of course, we are kind of supposed to not to prefer a certain religion, like the legal system is not supposed to prefer a special religion. But on the other hand, Christianity is embedded in the whole cultural and also in the whole legal system. So it's a very fine line where the law is going on, I think. And I found that very interesting that you highlighted those notions, like the notion of equity, for example, coming from also a kind of a Christian background. And maybe for our students which are not so which do not know the English common law system so well, and maybe could you like elaborate a little bit on this notion of equity, which is of course fundamental for the common law system, but which of course does not have an equivalent in the German civil law.
No. I'm a great advocate, by the way, of English lawyers knowing more about, you know, the continental legal system or civil law systems, because I think it's incredibly important to understand the working of the civil law. I mean, I think you can say in England we have in a way we have a sort of hybrid system. The common law is, you know, is an incredibly important underpinning, but of course in most areas of law it's overlain by statute. So in the area of for example, criminal law, it was all originally case-made decisions. You know, the law of murder was decided by various judges over many centuries, and that fleshed out what the law of murder was and the parameters of the law of murder. However, you know, modern law now puts most things in acts of parliament, so it's not purely, you know, a question of common law. And of course, the way in which when EU law came into the UK, lots and lots of regulations, EU directives, again, essentially, you know, a continental style of jurisprudence. So in a way it's a bit of a blend. But equity was this sort of idea of filling in the gaps, if you like, in the legal system. So where a case came to court, but the kind of existing system didn't really have an answer, and, you know, for example, in the area maybe of something like the law of wills or the law of trusts, and whether or not somebody could inherit property who couldn't point to a legal right to inherit property or a legal right to share in the inheritance, but nevertheless it was right as a matter of principle. You know, for example, they were a de facto child or an adopted child who had no other means of being looked after, or somebody who'd been a prime carer throughout the life of an individual, but nevertheless didn't have a legal right to inherit. So equity would step in and fill in those gaps. And as equity originally started out as a separate sort of legal system altogether, you'd have to take your case to a separate legal court. Eventually the systems just got infused, so that every court in the land just applied the notion of equity as well. And it can be, I think, quite a nebulous concept initially, but it's not so different in some ways to the idea of good faith, which does exist in the civil code. So, for example, in the civil code of Germany and France and Switzerland, you know, in contract law, this good faith is an important part. And so, if you don't have very, very clearly delineated terms of contract, and the judge has got to decide what the contract means, to fill in the gaps, you can use, you know, good faith in certain, you know, prescribed circumstances. So, you know, the two systems do in some ways try and achieve the same end, namely justice, but you know, by slightly different routes. But anyway, that's a little, potted history of equity. I think we have a question from, Paul Schaffmeister. Yeah, so the hand raising button isn't activated. So maybe if people want to ask a question, maybe just put your just say in the box you want to ask a question, and then we can call on you. But Paul, I think you can unmute yourself if you want to unmute yourself to ask a question.
Yes, thank you. First, just thank you for very inspiring and thought-provoking presentation here. I actually have two questions that I'd like to pose, and you touched on both of them in your presentation already. The first one being looking at the legislative instruments in the United Kingdom. and the protection of the freedom of religion enshrined in them, considering that the charter rights will probably disappear next year, with the United Kingdom then having exited, and then European law ceasing to apply in the United Kingdom, and then something that one might call the drive to get away scrutiny, judicial scrutiny, via abolishing the Human Rights Act, that certain political parties had planned to do that, perhaps still plan to do that, or just recently launched Commission on Judicial Review to perhaps curtail the ways to utilize these tools. Where do you really see freedom of religion going in the United Kingdom in the future? And the second part, which is really about Lord Justice Singh, that you have shown us a picture of, because I was always wondering, in Germany we have this rather fiercely conducted debate about nowadays headscarves in court, and female students of law not being allowed to act as a prosecutor when doing their traineeships in order to prepare for the bar. And I think Berlin has recently passed another neutrality statute preventing people wearing a headscarf from exercising prosecutorial powers in the courtrooms, whereas it seems to me that Lord Justice Singh sitting at the bench of the Court of Appeals really is not an issue at all, and is not debated. So I was wondering what your views on this perhaps slightly different approach to religious symbols attached to judges are. Thank you.
Two really excellent questions. Thank you, Paul. First of all, yeah, what's going to happen with Brexit? So, funnily enough, when I was, sort of coming towards the end of the first draft, and realizing, of course, that we were going to potentially have a complete kind of change in law. I mean, I said to the publishers, we absolutely cannot put the book out until we know what the legal landscape is going to look like, because it will just be out of date, straight away. And so we held off for a bit, and then of course, there was an extension, and then there was, a transition period, and we've lived with so much waiting and lack of clarity, and we still have it in certain areas in relation to, for example, free trade and immigration. But I mean, where we are in terms of freedom of religion, I don't think Brexit will make much difference for two reasons. One, I mean, the European Convention of Human Rights will obviously not be affected by Brexit, even if, and I think it's unlikely that the Human Rights Act will be abolished, certainly not at the moment. Our Prime Minister has got many other things to think about right now. But even if they did try and abolish the Human Rights Act, they're not going to abolish the concept of rights per se in England. Really, the debate is more about who decides, having what is perceived, in my view, incorrectly, to have non-elected, judges deciding cases. In other words, European Court of Human Rights judges deciding cases in the UK. So in other words, they would just sort of domesticate the human rights, but they would have to replace it with something. So the substantive rights would inevitably remain the same. And what they can do in any event, and frequently do, is try and strike the balance in certain areas involving religion in domestic law. In fact, in the area of religion, I mean, there are rights struck, of course, in anti-terrorism laws, and there are rights struck in education laws already. So I don't think Brexit per se will alter very much in the area of freedom of religion, and won't alter the balance that's struck in cases. And this commission into judicial review, and looking at whether judicial review needs to be curtailed, which my chamber's matrix, we've put a very strong, along with a number of organisations, strong opinion, about the importance of judicial review. We don't want to reduce it. It's already heavily curtailed by legal aid not being available for lots of cases, and the time limits, strict time limits. You have to challenge cases within 3 months of the decision that you're challenging. But I don't think that will necessarily lead to a curtailing of cases about religion. A lot of the cases actually that come before the courts have come up in the context of employment disputes. So those obviously would be anyway not caught or affected by any curtailing of judicial review. So I think religious cases are going to continue to be litigated, because there is so many, there's a balance to be struck which is not necessarily set out already in law. In other words, people, in order to work out what the answer is, will have to bring cases, if they can access legal advice and if they can afford to do so, to the court. And there are some really, I think, really complex cases, especially in the area of religious views on same-sex marriage, which apply in the way that, for example, same-sex relationships are now being taught as part of the national curriculum in the UK. That's led to quite a lot of controversy in schools, particularly where the parents are predominantly Muslim and fundamentally disagree with the concept of same-sex marriage. And it's also coming up in relation to service providers, hotels and people running small family-run businesses, bread and breakfast businesses. Are they able to discriminate on the grounds of sexual orientation because it interferes with their concept of religion? So those cases will continue to arise. So I think Brexit won't particularly affect that. And of course, while we are going to be officially outside the transition period come the 31st of December, there is legislation in place which means that until they change the laws going forward, then the current legal system will just remain in place. We won't have the right to go to the Court of Justice of the European Union, but no doubt if the Court of Justice of the European Union has made a decision which is relevant to a case coming before the English courts, even if it is not binding, they will no doubt have regard to it, because it will be authoritative and helpful for the domestic court. And then this whole issue about headscarves in court. I mean, again, it's interesting that you raise it, because has been such a vexed question in England, although in a slightly different context. So there's been a lot of discussion about not so much the wearing of headscarves, but the wearing of a full face veil, so that you can only, for example, see eyes. There have been cases about teachers who have been asked to remove their face veils when teaching children, and they have said that they don't want to on grounds of religion. And then more recently there have been cases about what you do with witnesses in the court system, witnesses who come to court to give evidence and you can only see the face veil. And there were a lot of discussion about this in amongst the judiciary and in the senior judiciary, with comments being made about, or concern being raised about, well, can you really understand somebody's evidence well if you can't see their lips and their mouth? Can you assess credibility if you can't see facial expression properly? What's interesting now is the science behind decision making, and the science behind the credibility of witnesses has sort of come to the forefront. And recent decisions about this have shown that what is the most important factor in deciding whether or not, or the most important factor in working out the veracity of a witness, is actually listening to what they say, not how they say it, not their facial expression. And that if you place too much weight on facial expression, you could be led down the wrong route. And quite recently, there was a Court of Appeal decision in the family courts giving guidance to courts not to place too much emphasis on the demeanor, and not to place too much emphasis on being able to physically see a witness, rather listen to what they say. And of course, there are lots of contexts in which witnesses are not physically present in court. So, for example, child witnesses need to be protected, and you wouldn't get them to come to court. National security cases often have government witnesses who can't be seen in court, so they give evidence behind a screen, or they'll give evidence by video link. So, we are already, as a legal system in the UK, well able to deal with witnesses who we can't see their faces. But you're right. I mean, there isn't really an issue about wearing a headscarf. So Muslim advocates wear the hijab, don't wear the wig. And Muslim judges similarly would not be required to wear a wig. And yeah, that isn't an issue. So it's interesting, what becomes, what is and what isn't an issue in different jurisdictions. Oh, Giuliano says he has a question. Giuliano, do you want to unmute?
Yes. Sorry about the bad English. I didn't practice English for a few years, but I will try to ask my question.
It sounds pretty good.
Okay. What do you think about the relation between religious values and the values in the secular law systems? Like we have the values from the modern society often, I think. And in Germany, we have this strong splitted the secular law system and the religion. There is a strong split, and as I understood you, in Great Britain, it is closer, it is together more, the religion and the secular system. Sorry. And what do you think? Is it important to look at the values that the modern society gives us, or is it important to look at the religious values from the past? And as you said completely correctly, I think we cannot split from the religious values, because the law comes also from the religious values. The religious values have also a lot of advantages, because they generate something general, something universal, something transcendent. And that is something the society values, like the modern values in society, cannot generate, never can generate. And that is because that is what I think, and what I look when I look at decisions from the Bundesverfassungsgericht in Germany, the court, that they often split too much from natural law, like religion law, like something like this, and just say we are a value law system. We build our right on values. And what is value? Value is from society, or value is from religion. And I think in Germany we split too much. Maybe, I don't know. We need something that controls something, because it is a difficult question. What right really is? What is right? Because yeah, the religion gives us something that is transcendent, objective, and values from society is always subjective. It's always going with the time, with the people, and everything. And yes, I think this connection is very important. And as you told, that in Great Britain this is more together. I understood it. Maybe you can explain something. Yeah.
Yeah, I mean, it's probably easiest to sort of talk about this through the prism of an example. So criminal law is a really interesting example of this sort of secular and religion sort of law divide. What is criminal in one country is absolutely based on, religion, in a sense. In the UK, it's based originally, you can trace it back to the 10 Commandments. A lot of our criminal law comes from the 10 Commandments, thou shalt not kill. thou shalt not steal. So yeah, so criminal law, modern criminal law, is absolutely secular. In other words, you can't raise a religious defence to criminal law. If you are caught smoking cannabis, then practically you probably won't be prosecuted, but you are committing a criminal offence. And if for example you say, well, in defence of the law of murder, I committed an honour killing in the name of religion. I absolutely lost control, and I didn't believe that my daughter should marry for love. I had arranged a marriage for her, and I lost control, and I committed this terrible deed in the name of my religious beliefs. No, I mean, that's not a defense in criminal law. And yet, as I said, what is considered criminal is absolutely very much based on tradition. And one of the very, controversial subjects, which I think will come to be litigated, and I know has been litigated to some extent in Germany, is circumcision. So female circumcision is absolutely outlawed under criminal law in the UK, and there is a specific act prohibiting it. There are also orders preventing women from being taken out of the country in case they get subject to female genital mutilation. In other words, it's not just a criminal matter, it's also a matter for the family law courts and for international family law cases. However, male circumcision is practiced in the UK and is not prohibited by any statute or by the common law. Although, if you took the elements of male circumcision, you could argue that they amounted to grievous bodily harm under English law, and they amounted to a criminal offence. But there has never been a prosecution for somebody carrying out circumcision. So I think this is, if you like, it just throws up this complexity of law and religion, and how ideas as well will evolve over time. I think it's perfectly possible that we will reach a place in the United Kingdom where it's decided that male circumcision is also should be criminally abolished. The reason why, of course, it hasn't is absolutely to do with the role of religion in a public space and not wanting to offend religions. For example, Muslims and Jews in the UK who wish to practice male circumcision. But it's an example of this, this very grey area between a secular legal system and one that is inherently underpinned by religious culture.
Thank you very much.
Thank you, Samantha. I was just wondering when you talked about the issue of headscarves in court, which indeed has been a big discussion in Germany. And this is just a remark concerning the situation in Germany. Indeed, as Paul has mentioned, headscarves in court has been a much discussed issue, but headscarves in the classroom, which was kind of the discussion which came before, also under legal terms had not been discussed as intensely as had been headscarves in courts. And I think, and this is also a thing concerning the legal discussion in Germany, maybe we should have discussed all these issues earlier. Because I mean, of course, those are different settings, but on the other hand, when we were talking about headscarves in classrooms, the German Federal Constitutional Court gave a decision, very famous decision, but actually in this decision, it just decided that it would be for the federal states, basically the federal court just decided it would be for the federal states to decide upon the regulation concerning headscarves in classrooms. And a lot of experts were very disappointed by the decision of the German Constitutional Court, because they said, well, this is not a decision concerning the issue. This is not at the heart of the issue. So it's kind of a déni de justice. I'm kind of a fan of the German Constitutional Court, but this decision, I think at that point was really was not a very good one, because everybody was waiting for a line how to deal with headscarves in classrooms, and the Federal Constitutional Court kind of denied to give a line. And so now you have like lots of legislation differing in each federal state, and you have a lot of judgments, of course, and it's very hard to answer the question if a headscarf in the classroom is allowed or not. I mean, if the teacher is allowed to wear a headscarf in the classroom. So I think it's very, I mean, of course, you have to consider each individual case, but on the other hand, I think the Constitutional Court in Germany missed the chance to give kind of hints in how you would, as a constitutional court, just to put some pillars into the ground, which could stand there firmly, and then you could have kind of built upon the roof and all the other things, and you could have turned to the details. But I think the Constitutional Court really missed this chance. And so I think the decision concerning the headscarf in the classroom was really, was a woman called Ludin. And this was really a decision which was disappointing. And so now I think the decision about headscarves in courts is kind of, we are kind of working up all this, because we kind of missed discussing all these things when we were dealing with matters concerning headscarves in classrooms. And now all of a sudden, when courts are themselves here in the fire, now the discussion really comes up as a really discussion. So I think we are doing this, which we probably should have done years ago already, just reflect upon how we deal with those issues. And I'm not neglecting differences between those two things, of course. Yeah, it's of course it's a different thing. Maybe it's even a different thing to wear a headscarf as a teacher than as a judge. Maybe it's even more influencing because you're teaching children. Maybe it's even more sensitive in the classroom than in the court. But the whole discussion which we are now dealing with in Germany, I think has to be seen in the light of the fact that we haven't had the discussion before. And we probably should have the discussion earlier. And so all this comes up now, and all this is raised by this head in the court discussion, headscarf in the court discussion. And I think we are dealing about a lot more than just headscarves in courts. So, yeah, and this is partly initiated by the déni de justice of the German Constitutional Court, I think.
Yeah, I mean, it's very interesting how much time, and I know we haven't got very much time left, how much time has been sort of, if you like, spent up academically, legally, with courts deciding these issues about whether women are allowed to wear headscarves or not. Because, I mean, in any society, whether it's secular or religious, on the whole, you know, a woman in a headscarf isn't really a threat to anything. And of course, there are assumptions made often, either, you know, in court cases or by society of, as to why women wear headscarves. I mean, there's quite a lot of research that's been done in the UK which shows that women wear headscarves for, you know, as many reasons as there are women wearing headscarves. You know, you can't make any assumption about why a woman wears a headscarf, and in fact, women are free to wear headscarves in most, you know, I think if not all places, you know, in the UK. And so that's, I mean, that's sort of, you know, one observation. And of course, we had a case that went to the House of Lords in England about the girl who wanted to wear the full jilbab, and she was actually at a Muslim school, predominantly Muslim school, and we have faith schools in the United Kingdom, and the school already had a uniform, and so the uniform was a shalwar kameez. So the Supreme Court, really, the House of Lords really decided not to interfere with the judgment of the school in that case. You know, the school said, we don't want jilbabs because we have a shalwar kameez, which is Muslim friendly. Most of our pupils are Muslim, and we don't want other girls to feel that they should become more, if you like, religiously extreme. We don't want to put pressure on other girls because we want them to feel comfortable just wearing a shalwar kameez, which is compatible with most, you know, most of our Muslim families' concept of what is appropriate. So that was a case where, you know, there was a lot of criticism about the decision. I think the approach to the court was not necessarily the right one in the way they analysed the convention, but I think the result, the non-interference by the court and allowing the school to strike the balance in that case, was probably a sensible one. But again, one comes back to this sort of, well, why not? You know, I mean, there are so many real issues, including in relating to religion, that the court, you know, and society might spend more time on. But women in, you know, in headscarves seems to me to be the wrong thing. It's often, I think, a cipher for something else, you know, concerns about extremism or concerns about terrorism, or, you know, whereas there is no evidence of women in headscarves really being the perpetrators of terrorism or even extremism. That's another discussion.
Definitely, but I totally agree with you. It's a cipher for something, and yeah. So the discussion is not really about the headscarf, but also about other things we haven't discussed as broadly as we should have discussed them. So I was just, I know we are already quite, we have spent some time here, but I really would like to ask you one question. You said that the concept of family, of course, in Great Britain, as in Germany as well, of course, is shaped by traditional Christian ideas. In Germany, this concept has been shaped and kind of in a modern way by the European Court of Human Rights. For children that are not born into a marriage, the European Court of Human Rights found that, of course, they have to have a right to inherit something and have to have the same rights as children that come from a normal marriage do. But all this had to be enshrined by the European Court of Human Rights, which is kind of, amazing somehow. But a lot of the German family law really comes, a lot of ideas kind of breaking up those traditional Christian ideas the German family law is full of, comes from rights, actually, which is interesting. Really a lot of really important decisions. I was just wondering how the situation is in the UK. Does the European Court of Human Rights, which of course has a different role in the UK, you talked about the Human Rights Act, but does this concept of family also, is it in the UK, is it also influenced by the judgments of the European Court of Human Rights?
Oh.
I think in Germany it is extremely.
Yeah.
And is it the same? I was just wondering. I don't know. Is it comparable the situation in the UK, or yeah?
So yeah, in a nutshell, yes, it is very much influenced. The way that the English court approaches decisions of the European Court of Human Rights is, obviously, if they're decisions in relation to the United Kingdom, then they'll be binding. If they're decisions which are in relation to another country but are directly or relevant, then the English court should try and determine what the what the jurisprudence is, and take these decisions into account, although they're not binding decisions. They're not binding like the Court of Justice decisions. So the joining of the EU was an absolutely fundamental change in terms of English law, because EU law became directly applicable in the United Kingdom. But the convention jurisprudence is to be followed, where it's consistent, but should be followed, but it's not absolutely binding. But nevertheless, it's had a huge influence, especially in the area of immigration law. And I mean, one of the decisions I referred to, or one of the quotes from Lord Justice Mumby was about a case of adoption. It was a de facto adoption of an Indian in an Indian family, and so the Indian parents came to the UK and they wanted to they brought their children with them, and then there was an adopted child, but there was no legal recognition of the adoption. So under the immigration rules, that child couldn't be brought into the UK because it was only a de facto adoption. The family had basically taken this child in and had treated him as their child for decades. And that's why Lord Justice Mumby recognized that modern society, a pluralist modern society, has to look at the culture and has to apply laws. Secular judges need to take into account the pluralistic society. So in that case, the judge did the right thing, allowed the immigration of the de facto adopted child who had no other parents, who'd lived with the family, notwithstanding the fact that the immigration rules didn't permit the entry of the child. And he did so under Article 8 of the European Convention, having regard to the very strong Article 8 jurisprudence in relation to children. So the Article 8 jurisprudence has been, groundbreaking for a lot of English decisions, and has changed the law effectively for decisions. The concept of what is the best interests of the child, which again comes from international law, from the the UN Convention on the Rights of the Child, but is really strongly brought out in the convention, the European Convention of Human Rights jurisprudence. Best interests of the child. I mean, these concepts are also embedded, to some extent in domestic law as well, but not in every area. So in the area of immigration, until relatively recently, immigration officers did not have to take into account best interests of a child in taking immigration decisions. That's now changed. And I think that was, again, influenced very heavily by international law norms.
Yeah, it's interesting that international law in this concern is more modern sometimes than national law is, isn't it? Yeah. So this is very interesting. Thank you, Samantha. I think we are quite ahead of time now. So I have the honor to thank you, Samantha, very, very much for your interesting talk, your patience in answering all our questions. Thank you very much. We are looking forward to your book coming out. I will order it for our library, definitely. And I thank you very much that you found the time tonight to do this presentation and to discuss those issues with us. It will be enough food for thought also for a third book in 10 more years. So I really do hope we will keep in touch, and we will be able to meet up again and discuss more issues concerning the right of religion and the secular state. So thank you very much, Samantha, and thank you everybody for Zooming in tonight. It was very nice to have you all here, and it was very nice that you asked your questions, and I think we really got a nice picture about the whole issue. So thank you all, And I hope in post-Corona times we can do this in person again in Leipzig. So Samantha, when Corona is over, I really will take your promise that you come to Leipzig in person, and we'll discuss a lot of these things in person then in Leipzig.
Oh, absolutely. I would love that. Thank you all. Thank you for the great questions, and best of luck for the remainder of the term too. Thank you. For you too, and a good survival of the lockdown in Great Britain. Absolutely.
Thank you. Have a good evening, everybody.